SJC-10079, Commonwealth versus Dennis Bateman.
Okay, Attorney Cotagnon.
Good morning. May it please the court, Amy Cotagnon on behalf of Mr. Dennis Bateman. We're here today, and I'm asking that this court reverse Mr. Bateman's conviction and grant him a new trial. We're here on a second time in 33E review. He had a motion for a new trial that was pending during the initial direct appeal that was heard before this court. And in that direct appeal decision, this court found a number of different errors stemming from withheld evidence, withheld promises, rewards, or inducements, jury instruction errors, closing argument errors. And the court did not find sufficient evidence at that time to reverse. Here today, we have 3 additional issues, each of which I suggest on their own should be enough for reversal. But I'm asking that this court really and truly consider how different this trial looks when you have this new evidence, when you have this withheld evidence, and when you have this witness who the motion judge found there's no reasonable strategic reason for not calling a witness, and if believed, would support Mr. Bateman's claim of actual innocence.
So, a quick question about the concern about the audio tapes and whether or not there was an issue with them.
Yes.
Is that actually newly discovered evidence? Shouldn't that have been something that was brought in the first motion for a new trial?
It was, Judge. It was brought in the first motion for a new trial. And if I could just clarify the record, because the motion judge, I would suggest to this court, made a mistake in terms of its decision that this was not newly discovered. The court did find that this was not available to Mr. Bateman at the time of trial, that the evidence, the technology has advanced such that it was newly available. But at the time of the first filing of the motion for new trial, represented by separate counsel, the motion for a new trial was filed. There was also a motion for funds that was filed for the expert. And of course, this court knows that defense counsel can't raise claims without evidence to support it. So counsel was seeking the evidence to support it. And he kept the court up to date on his progress in that regard. So certainly the motion for new trial progressed. There was an evidentiary hearing on some of the claims that had been granted. But the court, and these emails are within the record appendix, the court had reached out to counsel and said, what additional information do I need to decide the motion? Counsel said, this expert report is forthcoming. And as soon as he got it, I think it's the same day, he filed a supplement to the motion for new trial, adding that issue in before the decision. So that issue was raised as soon as it was viable, as soon as the report was completed, and as soon as it was done prior to the decision on the first motion.
What difference does it make? What is it that you say was problematic with it, and how would it have made a difference in the...
Sure, Judge. So there's a number of different issues there in terms of what was wrong with it. So I think starting at the outset, the officer who is the person who records the interview and is said to have uploaded it, filed an affidavit saying that he recorded this with a digital recorder and then he uploaded it straight to the computer, made no edits.
I don't mean the technical issues, I mean like the actual substantive issue. What is the thing that makes it exculpatory or helpful to?
So that's what I'm getting to, Your Honor. It was modified in multiple different ways, and there's proof from 2 experts with a combined 80 years of experience of intentional editing of the audio recorded statement.
What was left out?
An overstatement.
That is an overstatement, isn't it?
I don't believe it is. Taking the
It's
experts' own words.
inconclusive. They're not sure what happened.
Why don't you just tell us the record page where we'll find the statement from an expert saying they were deliberately modified?
Sure. In my reply brief, and I'm trying to look right now in my notes, in my reply brief, I know that
I'm going to look for that page while you tell us what it is. So
just have one moment, Your Honor. Each of the experts gave multiple different statements regarding that they could come up with no explanation aside from intentional editing.
that's something different. That might be their incapacity to come up with an alternative rather than an affirmative statement of,
Sure.
okay.
So on volume 2 of the evidentiary hearing, page 147, the expert said that one looks like an edit.
Page what? Sorry, I'm going to look it up.
Sure.
What was the page?
Volume 2 of the evidentiary hearing, page 147. Volume 1, 155, to me, they look like edits. 156, this one looks like an edit to me. This one looks like a pause or an edit.
Okay, so, and that's flatly inconsistent with the explanation for how the recording was made, because I didn't see that.
So it is, and that's the issue here, because the explanation is that it was recorded on a digital device and it was immediately uploaded to the computer. And what we know based upon what we have, so starting just sort of at the outset, the moment that this is uploaded into the computer, there are 9 iterations of this document, each of which have different hash values, which means they are not identical files. If he had plugged it in and uploaded it in the manner in which he says he did, there would be 1 or maybe 2 files because there's a bathroom break. They would have naming consistent with the machine, which begins with a letter A, B, C, or D. None of those exist. And the metadata would have the date of the event of recording, which is 4/20/2005. The metadata doesn't match, the names don't match, the hash values don't match, and there's multiple versions of it that are either combined or spliced, renamed, different things are happening, right? So we know that what he says happened didn't happen because it couldn't have happened. That's what the experts sort of explain. And then there's, other things here that are,
The experts say it couldn't have happened.
well, they say that if it had happened that way, we would have metadata that would match. We would have one file name that's consistent with the machine.
I know what you just said. I want your record support for that statement.
For which statement, Your Honor?
Each of the statements. You're saying, I think, your claim is that the experts are saying that the taped interview of your client was modified.
Yes.
Okay, and so I'm wondering where the record support is for that. Is that the volume 2 at 147?
So Judge, there's,
Volume 1 at 155?
that is where they're talking about the evidence of edit. Breaks in the recording are some of those that I've just cited. This was a 2-day evidentiary hearing where we went through all of the different things. So the metadata and the file naming and the hash values and what the recording device is capable of producing and what it in fact did produce here, which was an overloaded sound. We went over how there's an electronic network frequency that is a 50 hertz hum that is present in all recordings that
So
occur.
I understand the technical aspects, at least as far as that goes. I'm wondering where the experts draw the conclusion that this means that the tape or whatever was produced was modified.
So Judge, there's throughout their testimony,
So you don't have a specific site, it's just a generally.
I just named some of the sites for the court where they say this looks like an edit, this looks like an edit, and each of them at the outset at the conclusion of their testimony said that they could not come to the conclusion that this was an authentic original recording.
That's a negative.
That is, so I do have a technical question about the original recording. The original recording, I thought, and you know the record better than I do, is the Olympus device.
It was the VN2100 machine.
The Olympus?
Yes.
Yes, thank you. And that was uploaded, right?
Yes.
So whatever is on the computer is no longer original, correct?
So what the experts testified to was that what was on the device itself would be uploaded and it would contain the metadata of the original recording.
But what was uploaded is no longer an original. There's been a transfer.
There's been a transfer, correct.
Okay. So I guess given that it's an acknowledged transfer, I'm not sure why the fact that it's not original, which seems like it's undisputed, should matter in terms of your client's position or the expert's position, I guess, that there's been definitely a modification of the recording.
And that's why it matters, because they're holding this out to be an authentic original recording, and based upon.
But no, I mean, I thought it was acknowledged that the original is on the Olympus. At some point, the officer uploaded it to the computer.
Sure, and
at a second point, it was downloaded to
CD or something.
compact disc.
And the hash value.
So whatever is on the compact disc would certainly not be the original Olympus recording.
No, but it shouldn't have signs of editing.
It shouldn't have signs of editing.
And it should have.
And that's on page volume 2, 147, volume 1, 155, and 156.
So, Your Honor, I mean, there's 2 days of testimony that talk about, so the hash values is one of the things that I'm pointing to for how we know that there was modification made to it after the date of the interview.
And the hash value modifications are inconsistent with the admitted uploading to the
Yes.
computer and downloading to a CD.
Yes.
Okay, and that's where in the record?
If you could give me just one moment.
Sure, thank you.
On volume 2, page 11, there's testimony that the hash values of the duplicates provided by the police differed.
Where is the conclusion that the fact that the hash values differ means it's been modified?
So the conclusions were at the end of the testimony, and I can get those pages for the court, but what we did was we went through all of the different things to try to determine whether or not there was an issue here. So first of all, trying to figure out what the recording device was consistent with, looking at the hash values, looking at
I
the
don't
metadata,
need you to
looking
go
at
over
file
the
naming.
technical aspects of this. I think I quite clearly understand. What I want to know is where the experts articulated their conclusion as a result of all the hash values and the metadata being different and blah, blah, blah. It is modified.
So I think what they said was not, it was modified, it's that that you would expect it to be the same. So and I don't have every single site here at my fingertips, but I did file a very lengthy memorandum after the hearing that's in the record appendix that went through each of these topics and how both of these experts, and sometimes the Commonwealth's expert concurred with these on each of these topics. So the hash values, the metadata, the file recording. And what we have here is, there's announced start and stop times for the first part of the recording. He, at 1:30 into the recording, he says it's 12:09 p.m.
What has been changed?
So, and that's what I'm getting to, Your Honor. So he says it's 12:09 p.m., so we can infer based on a minute and 30 of that into the recording that it's 12:07.
What does your client say has been changed? This was his interview, right?
Yes, Your Honor.
What does he say has been omitted or changed?
So what I'm trying to explain to the court is that there's a number of minutes that are missing from this audio recording, just based upon their announced start and stop times. It should be an hour and 12-minute recording, and it's 58 minutes, based on what the police say the time is when they start and what the police say the time is when they stop, right?
Did your client submit an affidavit saying what occurred during the missing time?
He did not specifically.
Okay, so how are we supposed to hypothesize what may be missing in these 12 minutes?
I don't think the court needs to hypothesize.
Well, don't we, in order to find out whether there's been a miscarriage of justice in the conviction?
So I think the court needs to look at a few things here. The first of all is that when we're talking about destruction of evidence, which is what we're talking about here, it's a
Well, none of your witnesses testified to the destruction of
They
evidence.
testified to edits, Your Honor, edits. And
Well,
we have minutes of this missing of this recording that are missing.
And how does that cast real doubt on the justice of the conviction, which I think is the test that we articulate? I'm sorry to ask you these questions, but you're here to answer our
No,
questions.
I understand,
And you
Judge, but
seem very upset that we're asking you questions.
No.
My question is, I'm trying to apply the legal standard for newly discovered evidence.
Sure.
Assuming it's newly discovered, the question on prejudice is how does it cast doubt on the justice of the conviction? And in the absence of an affidavit from your client saying, I said something else, that's missing, what is your position as to how this casts real doubt on the justice of the conviction?
There's two things that I really want to make these points, because I want to take a step back from what's
Go
missing.
ahead.
So Mr. Bateman, before his trial, a month before his trial, said to the court, he's represented by counsel, but he feels compelled to get up and say, this transcript of my testimony is not right. I need these audio files because the transcript is wrong. This is not what I said to the police.
And he
He's
says,
saying
what's missing? What did he say to
He didn't articulate exactly what was missing, but if you look at the defense that the Commonwealth proffered and the defense proffered, they're only talking about Mr. Bateman's words. So they're talking about the Commonwealth, I think, seven different times.
It's not just his words. His DNA is on the belt.
Which
There
he admitted
are
to
4 or
touching.
5 people who see him there at the proper time. There's, as we said the first time around, there's overwhelming evidence here. So the fact that there's some missing pieces to his interview without identifying what's important, so what?
So this is the point that I was trying to make. So what? You've got evidence that the police are deliberately manipulating evidence.
Just anyone, you got to be more careful Does any of your experts say that? Because that's a really serious charge to put on a police officer when your experts are talking in negatives. They can't conclude based on this. You got to be careful or you're going to get in trouble.
And I'm going to add something to that, because there's even more to that, is your experts say some of the things that you say is wrong with the recording of Mr. Bateman's is consistent along all of the testimony, all of the recordings. There's all of this background stuff. So if we're still under the general kind of constraint of an abuse of discretion standard, back to how are you saying this really powerful affirmative statement that this is what they did?
So, and this is how, Your Honor, and I want to make this point that if you're cross-examining the detective who's saying, I just plugged this into the machine, and there's multiple different ways that we can show that that's not what happened, including the 9 iterations of this recording that are uploaded at the same time, that's exculpatory because it's impeaching this officer who's claiming something happened, and we know it didn't happen that way. And this officer is connected to every different part of this investigation. He's connected to these informant witnesses. He's connected to, not asking certain questions of witnesses and not investigating leads and all of these things. So that's why it makes a difference, because we're talking a lot about his statement. And in Mr. Bateman's recording, we have an explanation as to how the experts believe that this happened. And that's going back to the ENF, the electronic network frequency. There's this hum that should exist at 50 hertz across the entire recording. And there's breaks in that hum, which are signs, and they testify to this, that they can explain no other way aside from intentional editing. They've looked at every other explanation. There's no other explanation that they can come up with. But beyond that, there's a
volume 2,
mirrored hum.
147 or volume 1, 155. Are we going to get that quote, or are we going to get, I can't make sense of this, or I don't understand how this happened? It's just, they're qualified, I believe, but I haven't read through this whole transcript, but I'm certainly going to.
And yes, Your Honor, I think that you will see exactly that.
You're going to see quotes saying, I conclude that they deliberately.
No.
Of course not.
We can't say what they did or that they deliberately or didn't, but they will say, this looks like an edit. I can explain this no other way aside from
What does an edit mean? It means
a break in the recording.
Yeah, okay, but a break in the recording, there are lots of reasons why you have breaks in the recording that aren't malicious.
Well, so Judge, I think that they looked at that, right? They looked at, is there an explanation for this? Was there pausing? And that's not what the officer said
Let's shift
happened.
you to the next issue. So the witness, we have 2 other witnesses. One witness that Jubinville, the lawyer, doesn't call, is late to her dinner, and she doesn't see the truck. We have 4 other people who see this very distinctive van with, so again, how's that going to create a substantial risk of a miscarriage of justice?
Yes, Your Honor. So it's going to create a substantial risk of a miscarriage of justice because Mr. Bateman admitted that he was at the gas station earlier in the day. You have multiple witnesses that talk throughout the day of having been by the gas station. Some are at 5 o'clock, 5:30, different times like that. Mr. Bateman says that he had left and that he was in downtown Greenfield. We have a witness who, in her original testimony, puts him downtown at 6:45. You have, and that's exculpatory.
We have a bunch of witnesses who put him there at the right time.
So I disagree with that, Your Honor, because first of all, the descriptions
How many witnesses place him there? I can't remember, it's 6:30, 6:40 time period.
There's one person who says there's a blue van there at 6:24. That's the closest the Commonwealth can get, except for Mr. Williams, who says that he drives by at 6:30 p.m., the exact time that this witness says she's in the parking lot, and that he sees the van there.
Is he the person who sold him the paint? There's this person.
Yes.
So the person who sells him the paint sees the van at the right time, and because this woman who's late for her dinner and is not really paying much attention misses this. This is a reversible error.
No, Judge, because I think that you're making a credibility determination that's for the jury to make. So this person...
I've got multiple witnesses, and I have one witness who just doesn't remember it. And her testimony isn't it wasn't there. It's I don't recall it's there, right?
So what she says, Your Honor, is that there was a shiny red pickup truck parked out front. She says she does not recall seeing a van. And the court reconciles this with Mr. Williams' testimony by saying that Mr. Williams himself actually wasn't certain about the time. So it's possible that Mr. Williams actually drove by earlier. But what the court misses is that when she drives by, she's certain about the time because she's late for a reservation. It's 6:30. She's supposed to be at the Deerfield Inn at 6:30. She gets there at 6:32. She's confident about the time. She doesn't see a van. She sees a shiny red pickup truck, which the police do not investigate. And she sees two people inside of the gas station standing up, which means the way in which the court reconciles the difference between Williams and Allison Hamilton is to say that Mr. Bateman had already.
But there's one other thing, though. You're under, all of this is under the umbrella of your IAC claim. And at the beginning, when you started your presentation, you said that no reasonably fallible lawyer would have not called her. And there's a letter in the record, right, where there's an explanation from the lawyer to Mr. Bateman about why he doesn't think that it makes sense to do this.
So that's actually from prior appellate counsel. It's not from trial counsel.
Well, the issue is whether or not it made sense to do this, whether it was going to, and so we have the trial judge's findings saying there is a way to reconcile this, and so we're still under what the trial judge did with this issue, and saying it's not the silver bullet that you're saying that it is.
The trial judge actually found that there is no strategic reason. He just found the prejudice issue.
Right.
So,
we're still under that conclusion.
Well, but I think that this is a question for the jury to resolve because this is the critical time. Whether or not he was there earlier, she was alive. When Allison Hamilton drove into the parking lot, she was alive and inside the gas station standing with somebody, and there's a red pickup truck there, not a van. So that's a Bowden defense. That's a police failure to investigate, but it's also evidence, if credited by the jury, that Mr. Bateman is actually innocent, that consistent with what he told the police, he's downtown. He's not there any longer. So when you have all of these descriptions of different people that are saying, there was a black man with curly hair, Mr. Bateman's bald, different weights, different heights, different color vans, and everybody's just sort of muddling this together to say, oh, well, it was Mr. Bateman. But we have a witness who says at the time of death, because at 6:33 p.m., Leonard Mazzone pulls in, and at that point, she is dead. We know she's dead. Nobody else goes into the building. So that's the critical time at 6:33 p.m. And if the jury believes her, if the jury believes that this person in the shiny red pickup truck is standing inside the gas station with her at 6:30 p.m., and she's confident in that time, that would have been the last person to have access to her before she was killed, not Mr. Bateman, if the jury believed her. That's why it's important.
But we still have to weigh that against all of the other evidence of his guilt.
I think the jury needs to weigh that. That's
Why does the jury need to weigh that? We have this argument come up. We've had this argument come up several times recently. This is a motion for new trial. Doesn't the motion judge need to make an assessment of the weight or the value or the quality of what it is that the defendant is now seeking to have a new trial
sure.
with? Okay, so it doesn't look to me like the first question is, what would the jury do with this? It looks to me like the judge needs to evaluate, I have no other word for it than the weight or the quality of what it is that you're proffering to determine whether that meets the threshold for a new trial. Would you agree with that statement of the law? Okay, then let's follow up. Well, he did have an evidentiary
Not on this
hearing,
issue.
not on this one. So but here, isn't there like a chronology problem for you? Because even if we accept this witness's statement, it's about what she saw at 6:30. We have a time of death at 6:33. A disinterested and good percipient witness's statement that he recognized the van and the person at 6:24. This is a 9-minute gap, right? And a whole death occurs in there. And don't we have some kind of, maybe, I want to say, diminished value to a momentary spotting in that period that almost doesn't leave time for the death to occur and is inconsistent with what everyone else saw. Like, why can't the judge look at that and say, that's really not worth having a new trial over?
So I think that typically judges can make that decision. There's a few things, though, that I want to point out about the 624 witness. He doesn't recognize the defendant. He doesn't recognize the van. He says it's a blue van that he sees, right? So it's not as strong, I think, as if you actually look at that testimony, it's not as strong as some might believe. But what the court did here is tried to reconcile David Williams, who's the 6:30 p.m. drive-by, tried to reconcile that with Allison Hamilton. And what he did was he said, well, he could have been wrong about the time, and maybe the jury's going to discount him at the time, and maybe he actually drove by earlier. And that allows Allison Hamilton to drive through and then not see the van because the van's already gone. But what the court ignored is that she sees two people standing inside. So the court's sort of making this determination, oh, maybe David Williams, who was a critical witness, if you look at the Commonwealth's arguments, critical witness for the Commonwealth, maybe he wasn't actually right. So he's resolving some sort of discrepancies there without letting the jury determine, is he believable or is she? And that's the question. Is he saying, well, it's possible that the jury could have reconciled these in a way in which is not exculpatory. But here, I mean, where you have something this critical, this key, in a case where, it's a homicide case, Mr. Bateman is serving a life sentence, and you have a witness who really, if believed, shows that...
Was there any forensic evidence to suggest there was a second killer?
Yeah, there's 59 fingerprints inside the gas station that are not identified. There's other DNA profiles, mixed DNA profiles on the strap itself. And there's other DNA that wasn't tested. There's saliva on her ear. There's a whole slew of other DNA that has not been tested. So there is other forensic evidence that exists.
Is there anybody else's DNA who's under her fingernails?
No, Judge. Not that I'm aware of. No, Judge.
Or anyone else's DNA that was located on her? In other words, it was not tested, but was there anything that was on her that came up with some other person's
There's no
DNA profile?
Person that I'm aware of, Your Honor. The testing was focused on the belt, which is multiple profiles. There's inclusions of Mr. Bateman and another person, Anthony Cox, who has some suspicious behavior. There's footprints that are not attributable within the gas station to Mr. Bateman. Nobody determines whose footprints those are. There's 59 fingerprints that are unidentified. There's other forensics that could suggest that somebody else was there. And there's leads that weren't investigated. The shiny red pickup truck, the woman that Mr. Mazzone sees driving away when he pulls in at 6:33 p.m. There is evidence that's consistent with Mr. Bateman's innocence that frankly, some of the jury did hear, but this new evidence the jury did not hear. I think that I'm far over my time, and for the remaining issues, I'd rest on my brief. Thank you.
Okay, Attorney Gagné.
Good morning, Your Honors. May it please the Court. Stephen Gagné on behalf of the Commonwealth. Your Honors, I'd like to start with just two foundational frameworks through which this Court should assess the motion for new trial. The first is that it's beyond dispute that the evidence of the defendant's guilt in this case was overwhelming. That was a finding by this Court 2 years ago in the decision on the defendant's direct appeal. That was found by the motion judge in denying the motion for new trial, and none of the issues raised in the current appeal obviate the fact that the defendant's DNA and his DNA alone was found on the ligature used to strangle the victim to death. None of these issues touch upon the DNA of the defendant being underneath her fingernails, and none of these issues take away the defendant's
Why is this not newly discovered evidence, the expert findings of anomalies on the recordings?
For two reasons, Your Honor. First, the trial judge found that this issue could have been discovered.
Right, so the defendant tried to add that to the motion for a new trial too and was denied.
Exceptionally belatedly. And the reason I say that is because the motion for new
But counsel just represented that it was on the day after they received the expert report, which was the first time that they could actually raise it.
That's inaccurate, I'd suggest, Your Honor. And here's my chronology, and I think the record bears this out. The defendant filed his motion for new trial on August 31st of 2018. It was remanded to the Superior Court. The defendant then, with the court's allowance, amended and supplemented the motion on October 4th, 2018. The court then set aside 2 full days of court time to have a full evidentiary hearing on that motion, May 30th and 31st of 2019, and then took the matter under advisement. Now in the background, the defense is working and trying to develop another issue, but it's not until August 21st of 2019, after the motion's been under advisement for 3 months after the hearing, and a mere 9 days before Judge Agostini issued his denial, that the defense attempted to what they call supplement, but really it was the insertion of this entirely new ground. And Judge Agostini, specifically in the footnote to his motion, said, for the reasons stated by the Commonwealth.
When did the defendant get funding for the experts?
Well, I think the judge here was trying to strike a balance between not completely handcuffing the defense of exploring potentially viable
You don't
issues,
know
but
when
also,
the defendant got funding for the experts.
Pardon me?
You don't know when the defendant got funding for the experts. I can look it up.
Oh, it was throughout 2018 and 19, I believe.
Okay.
And it continued on even after the motion had been denied. But the judge specifically said, for the reasons stated in the Commonwealth's motion to strike, this is late. I'm 9 days away from issuing my decision, and this is the latest in a long string of interminable litigation in this case. So the judge, I think, was trying to strike a balance of, again, letting them explore issues, but also trying to move this case along. The judge also found that there were sufficient technologies and softwares available well prior to the motion for new trial being filed where this issue could have been raised. Much of the software and the programming that the experts in this case used, they admitted during the hearing that it was available in 2007, 2008. There were updates and software upgrades throughout the years. But the experts also said that their most important tool is the human ear. It's critical listening. And they could have done this even before trial. There was a representation in the defense brief that the audio recordings weren't turned over until a month before trial. I'd suggest the record belies that claim. The defendant was arguing that he wanted copies of the audio recordings a month before the trial, but defense counsel already had them. And for that reason, the judge found that this truly isn't newly discovered. It could have been raised, if not at the time of trial, well before the motion for new trial in 2018. But even if we get beyond a potential waiver issue or this not being newly discovered, the trial judge was well within his discretion in finding that these experts really weren't giving him anything conclusive. There was talk about anomalies of unknown source or origin, something as innocuous as the sound of typing in an office. One of the experts chalked up to an anomaly.
How about the two she brings up in the first part? Volume 2, 147, Volume 1, 155. What do they actually say there? Do they say that this is evidence of editing, or do they have sort of a more nuanced description of this?
It's always phrased in terms of possible editing or consistent with, could be, but can't rule out other causes. And on the issue of intentionality, which the court spent much time on this morning, I'd like to direct the court to some very specific passages from Volume 1, that being April 18th of 2024, when expert Lindsay Hawk was testifying. On page 53, lines 12 through 16, she said the following: all of the things that we're talking about here could signify deliberate or indeliberate editing. We're not trying to characterize them by telling you something that we can't know because we weren't there, but these are artifacts that could signify some kind of change in the recording. 2 pages later, page 55, lines 1 through 7, the witness is asked, based on your training and experience, can you opine whether intentional editing happened? Answer: that's a tough question. I mean, editing seems to have happened. Intentional is a step that I think an analyst isn't really capable of attributing. It could be non-accidental, but intentional is, not a word I would use. And then lastly, on page 101, the same expert, Lindsay Hawk, when asked kind of the wrap-up home run question by defense counsel, she was asked, you can tell us that based upon the sheer number of anomalies in Mr. Bateman's interview that it's consistent with redaction and possible active editing, right? And the witness replies, I think yes, it's fair to say that we can't say for sure that it didn't happen, which is relevant. I think it was like trying to nail Jell-O to a wall in this case. And when you look at the judge having an evidentiary hearing, letting this evidence come out, analyzing it as he was there on the front lines, he'd observed the witnesses, listened to he credited their testimony. He credited it in the sense that he didn't dispute that they were experts and that they had some experience in their field, but ultimately could be consistent with possible editing, intentional or
To
unintentional.
address the ineffective assistance of counsel claim, why not call Allison Hamilton? And assuming it was poor lawyering, why is that not prejudicial to the defendant? Addressing specifically counsel's argument that Allison Hamilton stated that she had seen two people, including the victim, in the convenience store or gas house station.
The motion judge honed in on a couple of different topics, reasons why this was not ineffective. Well, he did say that there's no good strategic reason for not calling her.
Right, so
The judge
moving
said
to the
no-
prejudice.
No prejudice. First and foremost, I think it's really because of what Allison Hamilton did or didn't say. When you look at her statement, and this was echoed by Attorney Nathanson, a prior appellate counsel to Mr. Bateman, Allison Hamilton said there may have been another vehicle parked parallel to the building, but it's hard to say for sure. Allison Hamilton also said, I don't recall seeing a van in the parking lot, but she never affirmatively said there was no van in the parking lot. This was a quick U-turn that she and her husband pulled through the parking lot because they were late for their reservation of the Deerfield Inn. She wasn't taking an inventory of all the vehicles, their make or models. It was a brief encounter. The judge coupled that and compared it with the 6 other witnesses, ranging from 5 p.m. to about 6:30, who all saw this distinctive, awful paint job black van, including the person who'd sold the paint cans to Mr. Bateman to paint the truck, and several of those witnesses, Candace Cohn specifically, Margaret Lone, they had receipts showing that they had paid for their gas at 6:10 and 6:22 p.m. respectively. So I think when the judge looked at not only there's not much substance to what Allison Hamilton said here, and given the parade of witnesses that the Commonwealth called, and the defendant's admission that he was there that day driving that van, admittedly he didn't say at 6 p.m., but in the grand scheme of things, and particularly the judge said in light of the overwhelming evidence of the defendant's guilt, this would not have made any difference whatsoever. So there was no prejudice from that.
Can you, I'm sorry to make you go back to a previous topic, but could you address the claim that they're missing minutes from the recordings?
Yes, Your Honor. So it is factually in the record that the original recording would be inside this handheld digital device that Sergeant Gadrow had just started using. It was 2005. I believe it was right on the heels of DGM Batista. The original recording is in the device. The moment he uploads it to the computer, we're then dealing with a second generation or a version of it. Then it gets downloaded onto a disk provided to defense. So it's already, we're getting further and further away from the original. Files
But
are
none
getting,
of that would result in missing minutes. Why the missing minutes? What's the explanation? Why doesn't that raise suspicion that these recordings were modified?
I believe the allegation of missing minutes is that when the officer announces the time at the beginning and the time at the end, we don't know if we're just 1 second past the minute or 59 seconds into the minute, and the difference of up to 2 minutes wouldn't necessarily mean that there was editing or time lost. It's just the officer's recitation as opposed to some
But we
digital.
just heard a representation that there are 11 or 12 minutes missing.
That's not my recollection that there is an affirmative established chunk of time missing. And when you back up for a moment, when you, again, talking about these anomalies or what was supposedly missing, first
How
of
do
all,
the experts describe, how do the experts come to the conclusion that there are missing minutes? I haven't read all through this. How do they discern that?
I think my recollection is that it's based upon the officer announcing the time at the beginning and announcing the time at the end, and whether they're looking at the same clock, what type of device it is that they're using. It's an inexact science, so I don't think you can really pinpoint down and conclusively say that time was lost. But in any event, even when you step back and look at this from a little bit broader perspective, let's not forget that on April 18th, and April 20th. 2 times Mr. Bateman was interviewed. Not only was there an audio recording, but then the police typed out the statement, he reviewed it, and he signed it. And he had a chance to make changes, to put notations in the columns. Even when he was reading his written statement into the recorder, the experts were claiming there were anomalies and cuts and pauses and edits when the words out of his mouth matched up perfectly with the words on the pages, showing that nothing was missing.
And did he sign the statement where he talked about the belt out of nowhere? No. Is that one of the things he signed, or is that one of the ones he didn't sign?
After his first interview, kind of on the way home, he mentioned it, which is why they invited him back on April 20th, and that's when he put it both on the recorder and on paper. And returning to Your Honor's point, we don't know what supposedly the police cut out here. Mr. Bateman, it's been 20 years since his 18 years since his conviction. We're still guessing at what supposedly exculpatory nuggets the police edited out in this malicious scheme. And there's also no acknowledgement in the defense's brief that the motion judge explicitly credited the affidavit of Sergeant Gadro, finding that there was no shenanigans here. There was nothing nefarious. And as the motion judge who presided over the trial, that credibility determination should be afforded special deference.
Gadro testified at trial?
He did.
And is he the person who interviewed all the other witnesses too? Or are there different police officers interviewing the different, like the person on the cash register, Whalen or?
That was also Sergeant Gadro and the late Lieutenant Gibbons from the state police. So he was the lead investigator. He interviewed the majority of the witnesses. I can't say he interviewed every one of them. But even with the audio experts, again, and I think this point was raised earlier, they're finding anomalies and wave shifts and who knows what throughout all of the recordings. So that seems to dilute or the claim that the police were maliciously cutting and pasting and snipping Mr. Bateman's interview to make it look more nefarious than it was.
Do you have a sense of how Whalen's missing interview one suddenly became found?
So there was a finding that it wasn't produced because apparently the wrong interview was duplicated or recorded over segment 1, and it was in post motion for new trial discovery that the Commonwealth reopened up its file and went through it and provided everything to the defense, and that's when it was discovered. So there was a finding that there was a discovery violation, but nothing intentional. And I would also note that with that witness, Mr. Whalen, there were 3 segments of his recording. The defense had segments 2 and 3, as well as a written statement from Mr. Whalen, essentially saying what he had said in the first segment, which wasn't turned over until most recently.
And his DNA is found under her fingernails, is that? So they did do a DNA of her body, and he's the only person who shows up on the DNA, is that right?
Yes, I'm not aware of any other third-party culprit DNA on her body other than the defendant's.
What about the representation that there was DNA found on her ear?
That is a portion of the record that I have not personally seen myself. If there was saliva on her ear, I'm not aware of any DNA testing having been done on it or any other profile having come from it. I think if I can just answer, I see I'm a little bit over time. There's always a selection of which DNA testing may be most viable in a case, and obviously here the ligature and under her nails. I think once Mr. Bateman's DNA was on those 2 points and he admitted being there and interacting with the victim that day, there comes a point where you say you can't test everything. Unless the court has any further questions, I would rest in the Commonwealth's brief. Thank you very much.